Hello, my name is Jim Wabandato. I'm a Program Development Officer at the Indian Land Tenure Foundation. You're reviewing one piece in the Foundation's Landowner Outreach Programming. ILTF is invested in bringing you tools you can use. This is one of our videos in the series on the American Indian Probate Reform Act Basics. Today's topic covers a broad overview of the law. The American Indian Probate Reform Act is a uniform Indian probate law passed by Congress in 2004. It applies to probates for trust property owners passing away on or after June 20th, 2006. It continues a federal policy to lessen the burden of managing all of the accounts related to fractional ownership by Indians of Indian land. AIPRA, most importantly, removed state rules of inheritance from the federal process. Prior to AIPRA, it was common for non-Indian spouses to inherit the land interest of their partner, and consequently, Indian interests were losing their protected political status. The law strongly encourages trust asset owners to write a will. There are two processes based on what you as the landowner do with your estate. Situation number one is an estate with a will. This should be considered the best choice. You make the decisions on what happens to your land and the rest of your property. Or situation number two is an estate without a will. The legal term for that is intestate. AIPRA eliminates certain owner rights and opportunities of heirs when an Indian dies intestate. First, an administrative law judge will use the American Indian Probate Reform Act to determine who gets your stuff. The law ties the judge's hands even more by reducing who can inherit your land. Two sets of rules, once again, apply to estates without a will. One set, for an ownership interest in land of 5% or greater, works a lot like the old days. Shares will tend to be divided equally, but your heirs will inherit as joint tenants with the right of survivorship. The second set of rules applies when an ownership interest in land is less than 5%. The rules here are much more restrictive. For instance, there is the inheritance of highly fractionated interests through operation of the single heir rule. This topic is discussed in another video in this series. And there are other ways not covered today that AIPRA will limit your rights and opportunities. The American Indian Probate Reform Act affects all trust assets for those who die after June of 2006. The main category of assets is trust or restricted fee lands, but it also lays out who gets access to your individual Indian money trust account funds. AIPRA affects most allotted reservations. I cannot repeat this often enough to landowners and agricultural producers. The law pushes Indians to write a will because AIPRA gives the government power to decide what to do with your property if you die without a will. And even if you own or use land on reservations with their own probate act or probate code, those may be even more restrictive. Please review the listings in this presentation and pay attention to the probate laws that affect your property or business to safeguard it for your kids and grandkids. This has been Jim Wabandato of the Indian Land Tenure Foundation, providing a brief overview of the American Indian Probate Reform Act. If you would like more information, we suggest you review the resources and materials in this online series at iltf.org or contact legal experts in your own community. Remember that with the right information and your active participation, you too might realize self-determination on your Indian lands.